I remember I was here in one of your colleagues' program, that's Ijoma, and I told her that the Court of Appeal decision was right in the sense that most of the issues were decided on technical ground. And I told my other colleague I had there on the studio that it is because election matters is not for the people on the street. Election matters is not for the voters. Electoral matters is strictly a technical matters. You must be aware that there are a number of days within which you should provide your evidence. 21 days after the declaration of result, you must put up your petition. So it tells you that even before the election result is declared, you must start gathering your evidence. It tells the court that 21 days after the petition is submitted, the court has 180 days to conclude the decision in writing. So these things and these provisions are contained in the Constitution. And what therefore it means is that you cannot, my lords just decided, you cannot expound those guidelines and those rules. And so I said that what happened in the election, in the Presidential Electoral Tribunal in the Court of Appeal was based, majority of which was based on technicalities. And I will agree with them. But looking at this decision right now, I love what the lead Justice Inyang Okoro did. There's calmness in this presentation. He took each of the issues. He looked at it vis-a-vis the law, and he looked at it vis-a-vis the common sense. Like it made recourse to the question posed by the lead counsel to the second respondent. That look, when he was talking about the 36 states, it's the issue of section 134. And he said, if, for example, a candidate wins in 30 states, and he loses, he fails to meet up the 25% under section, that will you say the person did not win the election? You see, this is reasonability, not mere law, because it is not exclusively provided in the Constitution. So I really give it to the Supreme Court justices. They were calm in their presentation. They made it very crystal clear. And you can see the body reactions of the lawyers. It was done on them that, oh, we didn't avert our mind to this part. Oh, you could see Kisuche nodding to say, oh, yeah, what you said is, I agreed with you. You could see it from their body language that they are from their mind concluded that, yes.
The point, sacking.
The point made by the Supreme Court justices was fair and it was just.
Mr. Otta, are you by any means surprised that this judgment was unanimous for both of the appeals? Well, both that of Atiku Abubakar and the PDP, and yes, that of Peter Obi and the Labour Party?
Well, yes, I would agree that I wasn't surprised about the result. In fact, I think it had always been what we were expecting, even from day one when they started that. Are they expecting that they're going to win? I had my own views on it, and I feel that a petition can only be as strong as how well it is presented. What facts do you have? What evidence do you have to support it? If you don't have that, no matter how you feel about it, even if you think you are right, if you don't have that information before an election tribunal, you should not expect to get a different result from what has been laid down. But I have a contrary view to his. Just on one simple thing, as a lawyer, I think like a lawyer. This has to do with the presidency of the country. It has to do with who we are choosing, and this is before the apex court. I cannot, for any reason, see my Supreme Court limited. It can look at any information, anything that is put before it, without its jurisdiction being trammeled on any level. I can't see how we will get full substantial justice if our Supreme Court says that it is limited. With all due respect to my learned justices, I have no argument with the decision. It's based on what it is. It's based on the law. But it's based on the law. It's based on sui generis considerations of the fact that it's an electoral tribunal. But I still feel that law is what the judges say it is. And if there are issues there that should be looked at, the Supreme Court has the right and the power. And that is actually enshrined in the Constitution under Section 233. Any issue that you feel that comes before the the Supreme Court, it has the right to look at it.
Don't you think that if the Supreme Court enlarges its jurisdiction beyond reasonability now, that it is also capable of opening other vistas elsewhere? For instance, on this particular issue of the CS zoo, if the Supreme Court had listened to Atiku's case and then acted on it, on the flip side will be those who will be affected by that decision, who have not been accorded the opportunity to defend a criminal charge, because it will be like trying to use a civil process to address what amounts to criminal allegation.
Oh, no, I'm not even going there.
So in what areas has the Supreme Court exercised its jurisdiction that you think it has not expanded?
No, you see, when I am uncomfortable, I appreciate the electoral rules and everything, and I accept the fact that we say it's a sui generis court. But I don't see how that improves our jurisprudence. I feel that the court should be free to look at anything that comes before it on its own terms. If it chooses...
Without rules?
No.
Because the courts are bound by rules. The rules have already been made to guide the operations of the court.
Yes.
The court is just like any institution.
Yes.
And any institution that operates on ad hoc issues will never get it right. You have to have standard rules of operation.
Yes, I agree that we have to have rules, but rules are meant to guide us. They are not meant to lock us in. All I'm saying is that it's in the interest of Nigeria and Nigerians that we should always have a Supreme Court that can consider everything on its merits or demerits and then decide on it. It shouldn't say that because it has these rules, then based on technical grounds. I remember some time ago, one of the legislators was asking the former CJN whether his court was going to be guided by technical justice or by substantial justice. And then it became a kind of, a parody of sorts. My point is that with the judges, for example, you have people like the famous Lord Denning. I'm sure you even have heard of Lord Denning in the past. Yes, he was saying, there was a particular case, I think it was Parker versus Parker, where in 1953...
Let justice be done, even if evils will fall.
Well, not just that. No,
we
not
know
just
that very well.
No, not even that one. Yes, that's part of it, but he was saying that the counsel in that case was arguing that there has nothing has been done on this.
Done before.
Yes, or something.
That's what I'm saying. It's
right.
In that case.
And
the fact that it has not been done before does not mean that it cannot be done. And heavens will fall if you do justice.
Thank you.
Will be happy.
Right. So the way I always look at law, I always feel that the judges should be free. So I'm not debating with this case because, like I said, it's what you present before the judges.
I get the point. And
right.
I think maybe Barrister Agiwa will still come and weigh in on this. Before now, a lot of people have spoken about the Supreme Court being a court of policy, and to that extent, it can enlarge its own jurisdiction beyond what the law has donated to it and all of that. Do you think the Supreme Court has acted as not a court of law here, but a court of justice? Because there's a difference between court of law and court of justice. And court of justice is what will bring in the Supreme Court's position as a court of policy.
We must situate some facts here. And that is what the Supreme Court has done elegantly. And that is the manner that I said it was well presented. Now, there have been cases. In short, there was a recent case in Bayelsa State that was decided by the Supreme Court 2 months ago. And it was a case of somebody presenting a member of the State House of Assembly in Bayelsa State. And it was that the guy presented a forged certificate. And the Supreme Court said, yes, if it can be established that he presented a false certificate to INEC.
There was a police report in that case.
So
the court was convinced that investigation had been done, conclusions had been made.
Yes.
It is not a case where you have to start investigating.
Yes, but it was a pre-election matter. The person who went to court before the election was conducted. And at that point, it was invoking the original jurisdiction of the court, not as an election tribunal. That is not bounded by 21 days, 180 days, and 60 days. So, and that is what the Justice Inyang was trying to say. That yes, ordinarily we would have received this evidence as a court
of first instance.
Of first instance. you can invoke our power under Section 22 of the Supreme Court
Supreme
rules,
Court Act.
which is ordinarily. But you are not coming as an ordinary court, because Supreme Court is an ordinary court as provided by the Constitution. But in this instance,
it's a special court.
it's a special court on election tribunal that is time-bound. That, for example, if Supreme Court, like he is saying, or like he wants the Supreme Court to assume, that the Supreme Court, for the purpose of facts, taking certain evidence, it means that the 60 days provided under Section 28, subsection 6,
It's not sacrosanct.
it's not sacrosanct. So one morning somebody can come and say, oh, I remember there's one evidence somewhere. Please, Supreme Court, for the purpose of fact, for the purpose of justice,
Allow me to go and bring it.
Then you will now negate
The
intention of fixing a time limit
to decide
during which election issues. Because we are talking about, like he said, while we are talking about the facts, governance must go on. How do you feel the president is feeling when you are going to Chicago to bring evidence and you are going about how do you think will be the state of the mind of this person? So there has to be a time within which all these things should be put together so that the issue of governance can be dealt with. So at this point, the Supreme Court is saying, I am not operating as Supreme Court this time. I'm operating under rules set up by the Constitution. And like they mentioned, he said that rule is like the rock of Gibraltar that can never be moved. We can't move it. You can't bring in your facts at this time because the time within which you should bring your facts within 21 days has expired. And within the 180 days that is provided for the Court of Appeal, sitting as a tribunal, it has even elapsed. Because the appeal which I should hear must be what falls out from the Court of Appeal. And these facts which you have provided was not what came out from the Court of Appeal.
It was more like an ambush.
I cannot now resume my ordinary jurisdiction
legal
as if I'm not an election tribunal, taking that evidence and go back as an election tribunal to listen to that. I will be ambushing the other party. I think it is very clear. And I think we should concede to that.
Kelly?
Okay, Mr. Kelly, let's look at the very last-minute decision by the Supreme Court to transmit this judgment live. Has it in any way added to the transparency of the process? Let's begin from there.
Before I come to that, let me go back a little bit to 1979. I have covered all the presidential petitions at the Supreme Court. In 1979, this thing almost, it was a similar case like this came up when the court was asked to decide the 12th to 3rd
Of
19 states. The issue came up, should we now begin to divide human beings so that we can arrive at 12th to 3rd? And the Supreme Court had to come to a decision. And the Supreme Court said, no. That is the same issue they wanted to import in the Abuja case. I remember
25%.
Yes, 25%. I remember Agbakova once said, I think it was in 2019 when he advised Atiku, said, don't bother to go to court.